So the nature of a will is that a will only takes effect upon death. So it doesn't matter how well drafted it is, what are the wishes expressed in that will, it will only take effect after death. So before death, there's nothing really that will can do for you, right?
Yeah.
On the other side, if you register a family trust and you transfer your assets into the family trust, there's a couple of advantages that grants you in your lifetime.
If you leave them property or inheritance under a will, there's very little that you can do to ensure that it protects them long term. So a family trust really helps in in long-term provision for beneficiaries.
The problems came when now we were discussing what would happen to their joint properties, right? Because they were like, if the husband dies first and they have bequeathed their assets to the wife, and the idea is that the wife will do the stewarding or the watching these properties with the intention that eventually these properties will go to their children.
Yeah.
A very practical scenario came up where now the husband wife asks, so if I die and I have bequeathed my spouse all these assets, and the idea is for them to eventually end up with my children, but then she decides to remarry and brings in another spouse in the picture and possibly other children in the picture. Or she even decides to sell these properties and go have a good life. What would happen, right?
Because before you go to court, you have to go to your area chief.
Yeah.
And that is a place where a lot of people just give up on. So you have to go to your area chief and get a letter from the chief. And I have had clients tell me, perhaps you're living in the diaspora, you've lived in the diaspora your whole life, and then you wrote a will and you're giving your children the responsibility to come and go with it to court. Where do they even start looking for their area chief? Do they even know the area chief?
Family trusts can also be such essential tools to be used as alternatives to prenuptial and postnuptial arrangements. Now, let me break it down. Now, this is the whole issue of matrimonial assets has been such a
hot topic. Every day there's a judgment.
So the courts are always producing judgment. At one point they say it's 50-50. At another point, now it's okay. And of course, this is guided by the law and how the law, changes over time. So right now we have the concept of contribution, where at the time when you need to divide the matrimonial assets, each spouse needs to prove what they contributed to the acquisition of these matrimonial assets. The challenge is one, the law itself will say both financial or monetary and non-monetary contribution is recognized. But the question is, there's no guidance as to what value we attach to certain non-monetary contributions. And even in monetary contributions, you tell me, if you're building a matrimonial home with a husband, do you keep receipts every time you buy cement? Do you keep receipts every time you pay the fundis? Leaving the courts to decide what your matrimonial share is in some certain assets is generally giving a judge the power to decide, you did dishes for 30 years.
This is
what value are you attaching to that labor that you did dishes for 30 years? And you took kids to school and you dropped them to school and picked them up, and you ensured that there was always meals in the house and the house was clean. So by not making the arrangements yourself, you're giving a random judge somewhere the power to decide what to allocate to that non-monetary contribution. And that has created a lot of problems over the years.
Hi guys, hi everyone. Welcome back to our channel. We're very happy to be here and we're very happy to have you here. For the people who are joining us for the first time, my name is Wanjiku Mushoki. I run a law firm called Wanjiku and Kanyiri Advocates with my very beautiful partner here, Wamoyo. I'll give her a few minutes to introduce herself. And thank you for joining us in this. This is our second video on this series. And here we talk about estate planning, we talk about trust, we talk about wills, and we'll talk more about them as time goes by. Anyways, Wamoyo, how have you been?
Muka tu poa.
Anything interesting happened in your life lately?
Wow. Not really. Not really. That one has caught me off guard. Next time I'll have something, but today, not really. My name is Kanyiri. I am also an advocate of the High Court of Kenya, and we are happy that you have joined us on our second episode on this podcast. And as she's mentioned, we talk estate planning. So thank you, and welcome back.
Thank you for introducing yourself again.
Wow, we're saying a lot of thank yous.
Anyways,
they need to stop.
Anyways, as we said, we talk about estate planning, and the last time we had a conversation, we talked about trusts, family trusts 101. We talked about what family trusts are. We talked about who can set up family trusts. We talked about the process. And I think if anyone joined that last episode, they do have an understanding, a general understanding of what family trusts are.
Yeah.
But today we want to go in depth, and by in depth, we want to compare them with, we want to compare family trusts with a tool of estate planning that a majority of us are very familiar with. And at least one in, this is a statistic I'm making up, but at least I know if I come up across like 4 people and I ask one of them, at least one of them has encountered a will.
Yeah.
So today we want to do a comparison of family trusts over will and see why are we really encouraging people to set up family trusts. And I think before we even do the comparison, because wills have a place in estate planning.
Absolutely.
Yeah, we cannot say that they don't have a place. There are things that only a will can do for you. One of them being appointing of guardians for minor children.
Yeah.
So a good estate plan will also consist a will, because wills have their own advantages. But as a practice, we do think that trusts have more advantages over wills, and those are some of the things that we are going to be talking about today. So, Omoyo,
Yes.
let's start with you. So I have a will, and it's a nice will, and I have come to you. Why would you still tell me to consider a family trust, even with this beautiful will that I have?
Okay. Now we'll start with basically what wills do. So with wills, what many wills will contain is that a will have your assets, it will have your beneficiaries, and it will have now how you want the assets to be divided amongst the beneficiaries. So you'll you'll say I have this property and I want this property to go to, my firstborn, and of course you write their names. Basically a will who does its distribution. Of course, it can go straight ahead and do what Olive has mentioned, which is appoint guardians. It can even go ahead and set out burial wishes, or, it's not always burial.
Very specific instructions.
Yeah, just how people want their bodies disposed or dealt with after death.
Yeah.
But the reason why I would still encourage someone to do a family trust, even when they have a will, and of course this is on a case-to-case basis, no one family has the same dynamics as the other. So these are things that we really, really custom make. Is number one, protection of assets. So the nature of a will is that a will only takes effect upon death. So it doesn't matter how well drafted it is, what are the wishes expressed in that will. It will only take effect after death. So before death, there's nothing really that will can do for you, right?
Yeah.
On the other side, if you register a family trust and you transfer your assets into the family trust, there's a couple of advantages that grants you in your lifetime. And, for the purposes of this discussion, we are talking about living trust. So the living trust are the trusts you set up, and they start working immediately upon setup. And we're distinguishing them with testamentary trust. So there's living trust where you set up and it starts operating immediately. And then there's testamentary trust where you do not set up a will during your lifetime, but you write in your will that whoever will be executing your will set up a trust and transfer the assets to the trust. So for the purposes of this discussion, we'll focus more on living trust.
Yeah.
Now, when you set up a living trust and you transfer your assets into this living trust, there's certain protections that already this living trust affords you by virtue of holding your assets. Number one, in the last episode, we said trust get incorporated. Now, the whole essence of incorporation is that they get a legal personality of their own. Think about the way companies exist, and they, for the purposes of the law, they are considered as separate from the owners. So a company is considered a separate legal entity from its owner. That's the same way with trusts. Trusts are considered as separate legal entities from the owners of those trusts. Now, what that means is that if you transfer your assets into your family trust, and so in the eyes of the law, they're not regarded as your personal assets, it creates very important shields. Number one, it's creditors. So if you're involved in trade and, a deal goes south and now there's a debt against you, maybe even a huge debt, or you sign for somebody a personal guarantee when they were taking a bank facility and now they have defaulted and the bank is coming for you and your assets, or you're involved in a profession, you could be a lawyer, a doctor, an engineer, whatever it is, the people who get licenses as individuals. Usually there's always this very live possibility of professional negligence suits or malpractice suits, or even having a car on the road. You never know what happens, and there's a huge liability against you. So whatever the case is, or whatever threat is coming for your assets, if you have shielded them, if you have put them in your family trust, it's a way of sort of shielding them from the liability that is on you as a person. So then let me give an example. If, for instance, today I had already set up my family trust and transferred my assets into this trust, and now somebody sues me for, I don't know, maybe my vehicle did something on the road, and now there's a judgment for whatever number of millions, I'm able, because now these people are not able to access my assets that are in my trust, I'm able to have more leeway to structure myself and see how to pay off that debt without necessarily endangering everything that I have worked for my entire life, right? So then the family trust will help you protect or shield your assets from creditors, from lawsuits, and even matrimonial disputes. And we're going to talk about, there's another point we're going to talk about how family trust can be used as an alternative to pre and postnuptial arrangements. I think I'll explain how family trust can help people with matrimonial disputes when we're explaining that point.
Yeah, sure.
But tell us another point for why somebody would consider a family trust as opposed to a will, or a family trust on top of a will.
Okay. I think another thing that we need to consider is when you come to me as an estate planner and you want me to draft your will, what I will deal with is what you have at that point.
Okay.
So what I will include in the will is what you have then, your assets at that point, and to whom you want the assets to go to. And let's say you're 30, you don't even have children, you're not even married. So it means that every time there's a major change in your life, let's say you have acquired a new property, you have disposed of an asset, you have a child, there's a change in circumstance in your life that requires a revision of your earlier instructions. So with wills, you find that there's that need for constant revisions depending on how your dynamics are changing. But there's a way we can structure a family trust such that it can be a long-term measure, that we don't need to do so many changes because of how we have structured it, so that if you acquire a new property, for instance, you transfer it into the trust because the trust already exists without having, or if you dispose an asset out of the family trust, you don't have to come back to me as the estate planner and change for me this. Or you have had there's a new child in your family, you don't have to now come back to the will and start adding it, because maybe in the trust will put instructions for beneficiaries also include, children born in the future or adopted in the future. So with a family trust, we are able to, I'm not saying that we can't revise a family trust, of course we can, but wills are more likely to have a lot more revisions and a lot more constantly than a family trust. And I think
just a fun fact, did you know that the law of succession provides that if somebody makes a will, and then after making the will, they contract a marriage.
Yeah.
And that marriage was not contemplated, specifically contemplated in the will, where you say, in the making of this will, I have plans to marry so and so, and you have to be very specific that you intend to marry, and this is the person you intend to marry. If the will does not have that particular fact, the moment you marry, automatically, by operation of the law, that will becomes invalid.
Yeah.
That's an outright provision in the law of succession. Just fun fact.
Yeah, so if you have a will somewhere and you drafted it and now you're considering marriage, you have to actually revoke the entire document
and make it start afresh.
Yeah, which is something that I think family trust we can avoid that. You can actually contemplate that sort of thing in the family trust setup and prevent that need to come and redo your entire estate plan. Okay, that's a very interesting fun fact. Thank you for teaching us that. And then I think also as we are talking about constant revision, I think another thing that we can bring in is as we said, you can be able to make long-term arrangements.
Yeah.
Also, you can be able to make long-term provisions for your children or your dependents. The way wills work is, if perhaps let me say I've passed on today and in my will I instructed my property or whatever I own to go to Wamoyo 100%. There is only so much I can control in the will.
Absolutely.
Actually, there is very little I can control about what Wamoyo is going to do with my property. Or let's say I have a child, I have passed on, and they're only maybe 18 years old, or they're just starting out life. There's only so much I can do to ensure that this property or whatever I've left to them serves them for a long period of time in the will. But with a trust, I can be able to do that because I can leave instructions to the trustee that when my child turns 18, instead of giving them everything that they're supposed to inherit from me, let me just give them a payout. Or when they turn 26, let them submit to you as a trustee a business plan for a business. If it's viable, distribute something out of my estate. And also you can be able to provide long-term for vulnerable beneficiaries. So people with children, beneficiaries with mental or physical disabilities. If you leave them property or inheritance under a will, there's very little that you can do to ensure that it protects them long-term. So a family trust really helps in protection in long-term provision for beneficiaries. And to kick this to you, we're talking about children a lot. What about couples?
This one is a very interesting one. I've been privileged to sit across a couple of couples. Wow, that's a good one. A couple of couples. Anyway, I have been privileged to sit across a couple of couples who are seeking advice on their estate plan. And one particular one, I remember we were discussing the possibility of a family trust, and they asked me for a quotation. I gave them a quotation. They felt, that sounds like a lot of money. Let's just do wills. Why not do wills? Or why not do a will? And they were asking whether they could do a joint will as a couple. And I told them no, because there are very many practical challenges that happen. Practically, will not work out with joint wills. For instance, if me and Olive, assuming that we're a couple, if me and Olive wrote a will and we say these are our assets and this is how we are bequeathing them, of course, there's a likelihood that one of us will die before the other. So what does that mean even when I die and my will is being read? But this will also has Olive's wishes. You see the practical some of the practical challenges that come with a joint will. So of course, joint wills are not something we recommend. And so when I told them that, they said, oh, so now we have to do 2 wills. Now they are considering the cost of the trust vis-a-vis now the cost of 2 wills. That's not what brought problems. The problems came when now we were discussing what would happen to their joint properties, right? Because they were like, if the husband dies first and they have bequeathed their assets to the wife, and the idea is that the wife will do the stewarding or the watching these properties with the intention that eventually these properties will go to their children.
Yeah.
A very practical scenario came up where now the husband wife asks, so if I die and I have bequeathed my spouse all these assets, and the idea is for them to eventually end up with my children, but then she decides to remarry and brings in another spouse in the picture and possibly other children in the picture, or she even decides to sell these properties and go have a good life, what would happen, right? And that's quite a quagmire for many people. And we've seen many cases where that has happened, where the first spouse dies, the surviving spouse is supposed to be a good steward of what has been left behind for the benefit of their mutual children. But then, other spouses come in, other, stepchildren come in, and now, or even they start selling. And these I have seen it happen. We've even seen cases on, in the media about some of these things. And, with a will, there's only so much you can do to protect that, because once you die, you really are not in control of what that person you've left your assets is doing, right? And also, so usually there's the option of granting a life interest. So you can grant a spouse life interest where they will have access to the asset and the benefits of, if it's a house, they can live in that house. If it's if the house is generating income, they can receive that income, but they cannot sell it. So there's a possibility of granting life interest. But again, a lot of people don't know about this. And even the law of succession, what it provides is that if one spouse dies and leaves assets to, the law of success. So when they do the succession, ideally what should happen is that the surviving spouse should get these assets, but they should only get a life interest. But practically what happens in Kenyan courts, that aspect of the life interest does not get observed. So usually the court will tell people, as a family, you go sit down, come up with a schedule of distribution, bring it to me, and I will adopt it as the order of the court. And many people do that. And because they don't know about that concept of life interest, you find that all the assets are now registered in the name of the surviving spouse without any safeguards as to how they will be preserved for the benefit of the children. Now, a family trust solves that whole situation very, very well, because when you're setting up the trust, now for the trusts that I have set up for couples, there are very clear safeguards of what happens after the first spouse either dies or gets incapacitated. And those safeguards are meant to ensure that eventually the final beneficiaries of these assets are the mutual beneficiaries of the couple, and that the assets are actually preserved for the benefit of those children. So with a trust, there are very, very good and very enforceable safeguards that we put in place just to ensure that for couples who invested together, they can ensure whether I am living or dead, that eventually my assets will go to my children, and no other, spouse will come in and, all of a sudden now people are having a good life in Malaysia with, what I worked very hard for and intended for it to benefit my children. Right?
Yeah. That's a good thing, because you'll be surprised how many couples ask me,
right,
why can't we do a will together? I mean, all these things that we own, we got them together, so why shouldn't we do a will together? And have to remind them, a will is a very personal document. It's just me. But I like what you said, that as a trust you can you can combine intentions of a couple.
And also, maybe just before you come in, so as we have mentioned that joint wills are tricky, but you can easily do a joint trust as a couple.
Yeah.
So even the cost.
Yeah, you're right.
Makes sense.
You're right.
Mm-hmm.
Okay. It's interesting that you brought up the issue of life interest. I think that's something that a lot of people are not aware about, actually. But since we're speaking about succession in succession court, another advantage of family trusts over wills is avoiding or bypassing the lengthy and sometimes very headachy succession process. A will makes succession considerably easier than where there is no will. At least there's clarity of intentions, and the court has guidance on how to execute the wishes, and there's the executors, and it's easier. But that doesn't mean that it's not going to be a headache. And some of the ways you can see, first of all, the probate process. I think in our last video we talked about what the probate process is, but for anyone who did not catch our first video, the probate process is that process of presenting a will before court so that the court can give go ahead for the executors to carry out the instructions of the deceased. And if you have been part of Kenyan courts, even when it's a simple process, just the process alone of consolidating the assets that are in the will, you're usually given 6 months. Even when there's a will, you're given 6 months and you're told, go and consolidate everything. So even if the process is going really well and there's no objections and everything, still time passes.
Yeah, and just knowing how the judiciary system works, the justice system in Kenya works, those of you who've interacted with it.
Yeah. And not just the justice system, even just the will also, because before you go to court, you have to go to your area chief.
Yeah.
And that is a place where a lot of people just give up on. So you have to go to your area chief and get a letter from the chief. And I have had clients tell me, perhaps you're living in the diaspora, you've lived in the diaspora your whole life, and then you wrote a will and you're giving your children the responsibility to come and go with it to court. Where do they even start looking for their area chief? Do they even know the area chief? So
I've experienced that.
You've experienced that with some clients, right?
Yeah.
There's a client who told me, by the way, I gave up. I was like, I'm done with this whole thing, because the chief process frustrated me even before getting to court. So the process of probate is usually lengthy. There are so many outside factors that influence how long this process will take. And not just that, even you wrote a will 30 years ago, now people are coming to enforce it. They don't even know where to start. Where are the titles? Where is everything? So if you can manage to bypass that entire process by setting up a trust, then why shouldn't you? Because trusts do not have to go through, especially if it's substantially funded. And if you're setting up a living trust, the issue we're talking about, where do they even know where to start? Because this thing is living alongside you, even your children are part of it. Even if you live in the diaspora, you're able to bring them, and with the understanding that this is our property in Kenya, this is where it's located, we have this family trust. So they don't have to wait until 30 years later when you're dead is when they now start to come scramble and looking for property so they can rush to court. So if you can avoid the headache, and I'm telling you it's a headache because I know people who have given up.
Yeah.
If you can avoid the headache, then why not?
Why not?
Go ahead.
And still on that point, you see now it's even a different case where the beneficiaries of an estate are adults.
Mm-hmm.
When it's children,
yes,
there's also the whole question of between the time the parent dies, and life does not stop for anybody.
Yes,
right?
Yeah,
life does not stop for anybody. So you'll die, but imagine your children will still need food.
Yes.
For dinner.
In the interim, yeah.
School fees will need to be paid. You could be given a few weeks or a few months sort of grace period by the school, but it won't be for too long. And so if the probate process is something that will take, at the minimum, I don't know of many probates that have taken less than a year, even the ones with a will, The entire probate itself is really very hectic. So the immediate needs that are needed by the family, with a trust, a trustee is able to step in immediately and have access to some cash, even for the burial wishes. It's funny that there are some people who die very wealthy, really, really wealthy. They have money in the bank, they have assets, they have things, but because there's no way of immediately accessing those funds, people have to do fundraisers, right?
Yeah, so they can.
And if your wish was not to have a fundraiser done for your burial, a trust will have been a very essential tool where the trustee is able to immediately step in, access some cash, ensure that you get a dignified send-off without having to. You can't even decide on a date for a burial because you don't know if you will have managed to collect sufficient funds for the burial. So the whole issue of immediate provision in the case of a trust, which is not the case with a will, is another really good advantage of family trust. I will tell you this into now. Family trust, I mentioned at the beginning, family trusts can also be such essential tools to be used as alternatives to prenuptial and postnuptial arrangements. Now, let me break it down. Many of you have heard about prenuptial agreements, right? Mostly they're called prenups. They're not a very common thing in the country, but whenever you're watching, movies in the West, they are quite popular tools, the prenups. And prenups is basically the arrangement you have before entering into marriage as to how your assets will be regarded. Like, the assets that I acquired before I come into this marriage, how will they be dealt with in the event the marriage ends? Now, the thing that happens is that, especially in jurisdictions or in areas where prenups are not very popular, if you try to even bring it up, certain relational challenges are very likely to come up. Yet, you still want yourselves protected, you still want your assets protected. Now, I would say a family trust will be such an essential tool to use as an alternative to a prenup, because all you need to do, let me even take an example of myself. If I was getting into a marriage today and I'm not really sure about how this thing will turn out, or what the intentions of this person are, and I would just want whatever I have worked hard for so far protected. For me, I will not even bring up the issue of a prenup with my fiance. It will be as simple as I will set up my trust, I will transfer my assets into my trust. Of course, I am the beneficiary, me and now my other beneficiaries will be the beneficiaries under the trust. Then I get into the marriage. Now, our marriage laws recognize trust assets as assets that are not subject to matrimonial disputes. So they're not regarded as matrimonial assets. So yes, I can get into the marriage and now we start working on our joint assets together and putting a structure for them, knowing that my personal assets are safely tucked away in my family trust for, whatever eventuality will happen with my spouse. So that's how a family trust can be used as an alternative to a prenup. Now, as far as postnuptial arrangements are concerned, again, not very popular, but basically postnuptial arrangement is just you deciding from the onset, if this thing goes south, if this marriage goes south, whether it's after 2 years, whether it's after 5 years, okay, I know people who even divorce even after a couple of months. But, for however long it may take for the marriage to break down, what will that mean for the assets that we have worked hard for together and now are regarded as matrimonial assets? Now, this is the whole issue of matrimonial assets has just been such a
a hot topic. Every day there's a judgment.
So judgments, so the courts are always producing judgment. At one point they say it's 50-50. At another point, now it's okay. And of course, this is guided by the law and how the law, changes over time. So right now we have the concept of contribution, where at the time when you need to divide the matrimonial assets, each spouse needs to prove what they contributed to the acquisition of these matrimonial assets. The challenge is one. The law itself will say both financial or monetary and non-monetary contribution is recognized. But the question is, there's no guidance as to what value we attach to certain non-monetary contributions. And even in monetary contributions, you tell me, if you're building a matrimonial home with a husband, do you keep receipts every time you buy cement? Do you keep receipts every time you pay the fundis? Yet, those receipts are the ones that the judge will be asking you for before they can allocate you a share in that property. Now, when it comes to non-monetary contributions, so non-monetary could be things like maybe the wife became a stay-at-home wife so that they can take care of, the home, the children, and what have you. What value do we allocate that to? When we were having a discussion now, about a week ago, I asked the people that we were talking to, leaving the courts to decide what your matrimonial share is in some certain assets, it's generally giving a judge the power to decide, you did dishes for 30 years.
This is
what value are you attaching to that labor that you did dishes for 30 years? And you took kids to school and you dropped them to school and picked them up and, you ensured that there was always meals in the house and the house was clean. So by not making the arrangements yourself, you're giving a random judge somewhere the power to decide what to allocate to that non-monetary contribution. And that has created a lot of problems over the years. So the use of family trust as a way to do postnuptial agreements is just deciding, as we are acquiring this property, how do we structure it right from the onset, at the time of acquisition, so that you agree, let us set up a trust for our family. The eventual beneficiaries in this trust will be our children. Our assets, will put them in this trust, and the idea is they will ultimately benefit our children. Along the way, if we go our separate ways, we can decide how to maybe share the proceeds and what have you, but at the same time agreeing that, or coming up with whatever arrangement. Again, it can be tailor-made from one family to the other. But yeah, that's a hack I have given you.
And that's a really nice hack, because then I think it also allows people to make some of these decisions when they are sober, because when you have to make these decisions when you're in the process of divorce, there's acrimony already.
A lot of it.
Yeah, so even coming up with that arrangement of, okay, this is what is going to happen to our property now that we are divorced and our children, there's already so much acrimony. You people cannot even sit at the same table together. And so if you can be able to make some of these decisions when you're a bit sober and when you can see eye to eye, it's a bit better than having to make these decisions when you're already very angry with each other. So that's a really good hack. And yeah, we encourage people to think about it and consider if they can use a family trust before they get married. I think I'm going to give the other advantage. We've been talking a lot about the probate process and the involvement of courts, and we have seen wills be contested and sometimes invalidated. And I think a question that would be in people's mind is, can the same thing happen to a trust? Can a trust be contested, or can a trust be invalidated? And the advantage I see of a trust over a will, first of all, wills can be contested by anyone. Let's start there.
Absolutely.
Anyone can come out of the woodworks because they will get wind that it's usually gazetted, right? Once a petition has been filed.
You have to do
there's a 30-day period. So anybody from anywhere can contest your will. So that's number one. They can be contested by anybody. trusts can be contested, or there can be an issue that has to go to court, maybe because of how the trust is working or whether it's not working. But I think that the advantage I see with trusts over wills is that wills can be invalidated in their entirety sometimes.
Yes, it does. They do.
They can, and they get invalidated in their entirety. Or someone contests and they bring in a valid contest or a valid objection, and the judge or the court has to alter the intentions of the testator. But with trust, even with the contestation, and courts are they shy away from invalidating trusts.
Yeah.
What they do is they fix whatever is not working. So if the problem is trustees, then they can fix the trustees. If the problem is if the issue is there's no accountability mechanism, if the problem is that the beneficiaries maybe cannot be able to access trust records, a court will be quicker to fix the problem and preserve the intentions of the creator rather than invalidate the trust in its entirety, which is very helpful, because then if something is not broken, then just fix what is not working. It's a really huge advantage over having your will be at the mercy of a judge or some random person somewhere who is contesting it. So I think it's important to mention that.
Yeah. So the other thing that family trusts really help with is preservation of wealth in a way that wealth can flow down generations. Now, how does that happen? For starters, if you distribute your wealth through a will, really, as we mentioned, there isn't much control you have over how that person uses that wealth. Right. So, for instance, if you bequeath something like a life insurance policy, and you have a good payout of 20 million and it goes to someone, you have no way of putting structures for how that 20 million will be used. Now, in the alternative, when you're using a family trust, you can create structures for when this 20 million is paid, assuming that it's supposed to eventually benefit one of your children, you can have a structure where once the 20 million is paid, it's not handed over to that child that you want provision for. You have a trustee ensure that this amount is invested, and you can go as into details of what kind of investments are you mandating the trustee to invest this particular money in? So you can specify anything from bonds to money market funds to, the international investment opportunities, and give instructions for when income is made from this 20 million. So how does it get utilized? So you can give specifics of pay for these, beneficiary, always pay their school fees, always pay their medical cover, always ensure that they have an upkeep. And that way you are able, because now the 20 million is growing from whatever investments you have put them. So you ensure that your child has provision and on one hand, but the wealth is growing. Now, when we flip the coin, assuming that this child was not a very responsible child, or they were, they have spendthrift tendencies, or they have a drug addiction problem, the 20 million could really be blown away within a couple of months, right? But you see, with a trust structure, you ensure that that wealth is preserved. At the same time, family trust grants people an opportunity to allow their assets to not be subdivided in very small pieces. So, for instance, you may have land that is, you may have say 20 acres of land on which you are growing, say something like pineapples. For as long as it's the 20 acres and you are counting on the economies of scale to do that business, then business becomes very, very productive. Now, if you have to bequeath that property through a will and you have 6 children, chances are you're going to have to subdivide this land amongst the 6 children. So even if the 6 children were to do the same business, but at now the smaller scales, the business may, the property may not still be very economically viable, but with a trust, you can put a structure for how the business will continue to run the way it was running, then have the proceeds distributed amongst the beneficiaries in whichever ratio you specify, or have it continued to be invested. So with trust structures, it's very, very easy to create a system where wealth is able to flow from one generation to the other in a way that a trust cannot accord, a will cannot accord you the same opportunity.
Yeah.
Right?
Yeah. Right.
Yeah.
And speaking of, I like that you brought up the preservation of wealth.
Yeah.
Another way in which estates are depleted is legal fees. At the point of succession.
Yeah.
And if your succession is acrimonious and problematic, lawyers will not, a lawyer will not refuse to, they will raise a fee note, they will raise an invoice, they will raise a bill of costs.
And the longer it stays in court, the more their invoices keep piling up.
Yeah, so you can imagine everything that you have worked for a very long time is taken away by a lawyer. Your beneficiaries do not benefit from it, but a lawyer somewhere who, and you will find that as a beneficiary, I'll appoint my lawyer. As the other beneficiary, you appoint your lawyer. So there are like 3 lawyers all litigating over the same estate. So the more the acrimony continues, the more the costs and the estate is being depleted.
So, and just before, I'm sorry for cutting you short, it's funny because I've read a case. Okay, no, this one is in the public. This one is already out in the public. So I remember when I was reading Obama's book, Dreams from My Father, he clearly mentioned in his book that when his father's estate was being, when they were going through the succession, actually by the time they were finalizing the succession case, the amount of money they owed to the lawyers was more than what was being left to be subdivided amongst the beneficiaries. So if you think tunasema that legal fees can eat into wealth, it seriously can eat into wealth.
It can.
Yeah.
It can. It really can. And lawyers will raise invoices in the millions. It's not in the hundreds. It's in the millions. And that's why family trusts might be better because then they might be an investment at the point of setting up. As we said in our earlier video, it depends on what kind of professional fees that the lawyer charges you and also the cost of funding the trust. While it might be a huge upfront cost, or it might look like a big cost at the onset, it saves you a lot more. First of all, in the long run. First of all, pain-wise, inconvenience-wise, and then now the actual cost.
People even pay people because, say, your father has died. You had an idea they had some piece of land somewhere, say in Kilimambogo. Do you have an idea where this piece of land is?
No.
So you'll go looking for his friends or people who knew and pay them to take you to the site. You can imagine, so when money starts getting depleted at that level.
At that point. Or you need a surveyor to show you where the big coins are. And a surveyor is not going to spend his day and not charge you something. You have to pay for his fuel and the cost of that. So, yeah, you're right. The costs are not only going to get depleted in court, even in the small day-to-day of locating where everything is also already a costly process. So, I think let me segue this back to you. What else? Why else would you tell someone who has a will to set up a trust?
Now, something else that is very, very important for people to consider is planning for incapacity. Now, incapacity could be as simple as something has happened to you, you are on the road, there's some accident, and now you are in a coma for 2 months, 3 months, however long. So that is temporary incapacitation or even permanent incapacitation, assuming you don't make it. But incapacitation is something that people do not plan for, right? And remember, even if you have a will and you get incapacitated, the will does not kick in anywhere,
you have to wait,
right? Because the will can only kick in literally after death. So if you're incapacitated and you have money at the bank or you have all these assets, there's still no structure for how somebody will ensure that your beneficiaries or your dependents keep, living life and, getting access to food and school fees and whatever it is they need. Because again, we said life does not stop for anyone. It's the sad reality of life. Life does not stop for anyone. Children will continue wanting to eat. Even in your coma, school fees will still be...
Just to cut you short also very quickly, we are talking about your dependents a lot.
Yes.
But what even you yourself?
Yeah.
You're in a hospital, in a coma.
Yeah, your bills.
Your bills?
Where's the money coming from?
Where is the money coming from for your hospital bills?
Very, very good point. So wills cannot protect you in the event of incapacity. So usually the only thing that can help you in the event of incapacity is either a power of attorney. So assuming that you had appointed somebody, you had given someone power of attorney when you were still good, that person can step in. But you see, not many people think about, let me give someone power of attorney in case of anything. But even if you give power of attorney, again, it doesn't have safeguards of what can they do, what can't they do, what are the boundaries within which they are operating. So again, powers of attorney, in as much as it's a legal solution, it has its challenges, right? The only other legal way of ensuring that somebody takes care of your affairs during your incapacitation is going to court and seeking something called orders of guardianship. Again, it's a whole legal process. And, as we've discussed severally in this episode, the justice system, just the way it's designed, it's not the most efficient, right? So even before somebody can go to court and petition to be appointed your guardian to take care of you and your dependents while you're still incapacitated, it's quite a really long process. And again, there are no safeguards within which this person will be operating from, okay? So then a family trust comes in, right? And so with the family trust, because it provides that your successor trustee can step in the event of your incapacitation, somebody is able to step in immediately and take care of things. Take care of your medical bills while you're in the hospital fighting for your life, take care of your children, ensure they continue having food on the table, ensure that they continue going to school. Whoever it is that it's dependent on you, their life doesn't have to stop until you're back to, until you are able to recover. So, again, as we've discussed, remember when we started with family trust from the first point, it will do all these things, protect you from creditors, protect you from matrimonial disputes, do all this. So I guess I don't know if there's anything more we can say to convince you of the really untapped power of family trust, right? So we have two more points, and Olive is going to take us through them, and then, so
I would also like to say something small about incapacity planning.
Yes.
The thing we always say as estate planners, and you and I, is if you don't decide, someone will decide for you. If you don't plan, someone will plan for you. If you, for instance, if you were to become temporarily incapacitated and there's need for someone to apply for those orders to take care of your affairs, you don't have control over who it is.
Exactly, it could be anyone. It could even the person who hates you.
Yeah, perhaps the person, or perhaps you are estranged from family. You're estranged from your family, and this thing has happened to you, and you're incapacitated. And guess who is stepping in the shoes of in your affairs? That family member that you don't talk to or that you don't get along with. But what you're saying, other than taking care of bills and taking care of this beneficiaries, also gives you a choice over who is going to run your affairs, and it doesn't leave it to the mercy of other people who you would not even involve in your day-to-day. So I think that's a really good thing I find about family trust. And then the other two things that I can talk about is, of course, preventing family disputes.
Okay.
And I want to bring in the aspect of people know their baggage.
They do.
You usually know mtu anajuanga mahali mambo yalienda mrama or maybe they don't know sometimes, but sometimes you can usually foresee the kind of disputes that would arise from your family arrangement. or you have, or we all have experience. We've seen the kind of disputes that can arise. You have worked very hard for your property, and then you pass on. Nothing, no plan. You leave your wife, perhaps, and that's something that has happened to us personally in the family, where one of my uncles passed away, and then he left his wife, and now the brothers of the husband are coming to, she was being kicked out the day of the funeral.
No.
Can you imagine? She's grieving her husband. They have lived together for a very long time. And then suddenly these random men who are brothers of the husband are coming to say, okay, this property that you've lived in, that you have built together and you have worked together, belongs to our brother. And by the time watu wameekelea maua ya mwisho, ukuwa umetoka.
Oh my God.
And so those kinds of, or we've been seeing it in the news, so many disputes. You are telling me about, I think, Esther Musila.
Yeah.
We saw it with Justice Majanja, and he's a lawyer. He was a judge. We've been seeing the family disputes that arise
crop up and become everybody's
business at that point. So a family trust, you can use it to prevent family disputes, and you can use it to anticipate some of these family disputes. You can be able to exclude some people. You can be able to also keeping it private, that nobody knows what is going on with your property, and so there isn't the chance of just somebody just coming out of the woodworks and being like, I need to be provided for. And also, you can leave very clear instructions for your family. This is how I want you to do things. And as part of setting up family trust, we come up with this document called the Letter of Wishes.
Yeah.
And a Letter of Wishes is just a supplementary to the trust deed, that even when you're gone, I like to call it, for me personally, I don't know whether that's illegal, but I like to consider it as a love letter to your dependents, where I tell them, this is why I did this. This is why I set up the family trust like this. These are our values. So where sometimes people are not even clear from the family trust or the trust deed, they can even go back to your Letter of Wishes and say, these were dad's or mom's intentions. And so I do think that it's a very good, there's only so much you can prevent in a will. There's the most you can do perhaps is distribute. But with a family trust, you can be able to give even more specific instructions that allow your family to even understand what it is that you wanted, and what to do when some questions arise. And then the last thing I would say is family trusts are good for business continuity, for businesses, right?
Absolutely.
If you run a business, we've seen situations where somebody passes on and the employees are left scrambling because there was no structure
for
succession. You can use a family trust to ensure business continuity. And one of the ways we do it is family trust owning what? Shareholding in family companies, or giving instructions in the family, in the trust deed of how the business should be succeeded, giving powers to trustees to continue the business. So you can use a family trust to structure how the business is going to succeed you better than you can do a will. Again, we said there's only so much you can control through a will.
Absolutely.
So perhaps the most you can do with a will for a family business is, maybe if there's a company that has shares, just bequeath the shares to so and so, and you can't leave. It might be difficult to leave specific instructions on how the business is going to be run, or maybe even the people you're leaving the business to have zero experience.
None. And there's even the fact that those shares that you are bequeathing people, they have to go to court. So what is happening between the time that this matter is in court, and there are employees who need to be paid, there's stock that needs to be paid,
exactly. So I can imagine a situation where perhaps there's even a corporate trustee, and the corporate trustee is managing your assets that are in are in trust and you've passed on, and some of those assets are business assets, there's continuity anyways. Things don't pause so that the family can reorganize itself and reorganize the business. At least there's guarantee that things, even if things might, of course a death will shake things a bit, but the shakiness of it can be revived quicker than if we have to go to court and deal with all the things that come up with probate. But I do think we do need to maybe in the future sit down properly and talk more about business continuity and succession planning. I think it's also very unfortunate sometimes how somebody has built a very successful business and then they die and then in a year everything is gone. So stick around.
We are going to have that conversation about continuity of family businesses. Anyway, if you have watched up to this point, thank you very, very, very much. We hope you've learned something. We'll again continue having these discussions. And in case you'd like to reach us, we're going to put our contact details on the description box. But thank you so much for watching. We'll urge you to subscribe, share, like this video, and stay tuned until we see you next time. Bye-bye.
Bye.